Welcome to San Francisco CASA's webinar on court report writing. I'm Sue Lockyer, Senior Program Manager with CASA, and I want to thank you for taking just a few moments to learn a bit more about court report writing. In this training, we will review why we write court reports, what the goals are, some of the process, some tips and tricks and common mistakes to avoid, and really focusing in on the important necessity of being fact-based and non-biased in your writing. So we write our court reports first and foremost because it's required by the California Judicial Council. The judge and all members of the team expect and rely upon your court report, and it really is your strongest advocacy tool. In court, the judge often acknowledges the court report, and they do rely on your take and your recommendations to make their decisions. The purpose, as mentioned, is to make recommendations. Once you've been serving on a case for 4 to 6 months or more, you will be making recommendations to the court for what decisions should be made on the youth's case. You'll be lifting up the youth's voice, providing a lay person's perspective, and really adding a unique perspective and character and charm when you lift up the strengths, the personality, the progress of the young person, which often is not found anywhere else in any of the reports that the judge is reading. You'll be writing your court report in Advocate Link. You can see in the bottom right corner, there's a button for court reports. We've made it streamlined and easy. Advocate Link takes care of all the formatting for you. This is a sample of what a court report looks like, but don't worry, you'll just be filling in the content and we'll take care of all that fancy formatting. As you may remember from core training, in our court reports, we'll be writing about these advocacy areas. So there's a section for each advocacy area in your court report. It's okay if you don't have a lot of information for every section, but it is important to, over the course of your time as a CASA, to investigate and try to learn about each of these advocacy areas so we can share with the court. When you're writing, it's important to think about who's going to be reading this report. So, of course, the judge, the social worker, and the other attorneys. But it's also possible or even likely that the young person, when they turn 18, will read these reports. They will have the right to access their files. It's also possible that the biological parents will read the report. So we want to be really mindful about being respectful of dignity and confidentiality, and really sharing what the court needs to know and not sharing every single detail of what you've learned. We want to be factual. It's somewhat like being a reporter. So you're not going to be sharing what you think is happening or assume or conclude. You are going to be sharing what you have observed, what you have learned. We really ask you not to write sentences that start with "it appears that" or "it seems that," because we want it to be something you've actually seen, heard, learned, and not something that you have just concluded on your own. We want to lift up the youth and have it be youth-centered. The body of the report should be entirely about the youth. And there are sections where you will be sharing what you've done, but the body of the report should be focused on the youth and what is happening with them, not so much on what you've been doing in your advocacy. And then, of course, like all things at San Francisco CASA, we want to be strength-based. We want to lift up any progress, however small. Celebrate strengths that you see. Any small wins, we really want to take a moment to appreciate those. So writing without bias as many of you likely already know, means that if you make a claim, you need to have evidence or support for it. And these are some examples of a few that have good evidence and support and a few that don't. So Cindy is very loving with Jasmine is a claim, and the evidence is that you have seen every time a visit ends, Cindy's waiting for Jasmine with a big hug and smile. So that's your evidence. The next claim really doesn't have appropriate support. Sammy seemed okay with the recommendation. How do you know that? Well, he had a blank expression. Well, truly, that can mean many different things. It's possible he didn't understand what the recommendation meant at all, or it's possible that he shuts down and goes blank when he's stressed. So these are some examples for you to read through and consider when you're writing that each claim you make needs to be supported. Court report writing is a collaborative editing process. You will start a draft, and don't worry, it does not need to be perfect. We've worked with hundreds and hundreds of advocates, and we understand that you are not a professional court report writer, and it's okay. So you're going to start a draft, giving it your best shot, and then your case supervisor will provide feedback to you. Some key elements are not copying from a previous court report. That is a big no-no, and you will be asked to rewrite if you do that. It's just disrespectful to the judge and the team who have already read your previous report, and also it's not, it lessens the impact of your court report. We also want to make sure that what you share in your report, any recommendations or evidence, is not going to surprise the team. So that means that you should have had shared this information or been in conversation with the social worker and the youth's attorney before you include information in the report. It's a weeks-long process of back and forth writing and editing. We are required to file the court report at court 2 weeks to 10 days before the hearing. And so we start the process pretty early. It's okay if we need to add things as we go, if situation changes or there's more information, but we do start the process about 6 weeks before the hearing. And you'll get reminders for that. This slide is an example of what some edits might look like when you're writing your court report. Take a few moments to read through this. What do you notice about the sections that got deleted? And what do you notice about the additional sentence at the end? Likely you have seen that we want to avoid putting condescending or judgmental statements into our court reports, but really try to address or name the problem, but speaking in more general and neutral terms. And your case supervisor can help you with this. If you're not sure how to say it, just ask for help. This is an example of a question you might get from your case supervisor after you've submitted a draft. They might write back and say, wonderful, how do you know this? Can you share an observation to support this statement? Again, because we always do need to be supporting our claims. These are some common questions you might get from your case supervisor when you're in the court report writing and editing process. I will call out the first question because often advocates feel that they want to share everything they've learned with the judge. But sometimes the judge does not need to know every tiny detail about every visit or personal information about, let's say, a teen's sexual identity or sexual explorations, like that is private information. And unless there's a problem and a need, it's not important to include that kind of information in the court report. We just want to be thoughtful about what we share. The goal is not to share everything you've learned, but to share information that's going to help the judge to make good decisions for the youth. So when you're starting on a case and you're new, we ask that you not make recommendations probably for the first 6 months, depending on the case. Your case supervisor can help you make this decision, but when you're starting, you're a stranger to this child and their family and their resource family. And it's not appropriate to be making recommendations about whether they should stay in the system or stay in their placement when you're brand new and still learning. We also want to revisit the difference between stated desire advocacy and best interest advocacy. Both need to be included in your court report. And stated desire is what the child says they want. That's important for the judge to hear. Best interest advocacy is your assessment based on what you've seen and learned about what will be best for the youth. And sometimes they might be different. Here's an example of when stated interest might be different from best interest. We have a 7-year-old who is constantly telling you that she wants to return to her mother's care. So that's her stated interest. Take a moment to read through the facts to consider that might inform best interest advocacy. This is a complex situation and difficult to figure out best interest advocacy. You may need to gather additional evidence before you can make a recommendation. You should definitely consult with your case supervisor before making a recommendation. And it's possible to just not make a recommendation if you're not really sure. You'll be submitting log entries for your advocacy time. So your visits, the meetings you attend, even the admin work, writing of the court reports and entering your logs counts as time spent in advocacy, and also your travel, right? All the time spent in the car, getting to and from visits, that's also in there. Your log entries will help you when it comes time to write your court report, because you'll have written in there details, important details about visits, perhaps names of people you want to include in the court report and dates. And generally will help to jog your memory, because court reports are written twice a year. And well, I don't know, if you're like me, you may not remember every detail of what happened 6 months ago. So logs are really important to be doing regularly and can really help to inform your court report. Some things to consider. If you're serving a teen or a non-minor dependent, someone who's 18 to 21 and has voluntarily opted to stay in the system, you really want to ask them about what they would like you to share in the court report. And of course, we always invite and encourage them to attend their own hearing if they want to. Often youth don't want to because it's either takes time during school hours or it's just not fun and it's a little intimidating. But especially anything that is personal, you want to ask them if they're okay with you sharing that. As mentioned before, please do not recycle old writing. Even if not much has changed on a case, try to rewrite it in a new and fresh way. Also, judges love to see pictures. So if you've taken pictures of the youth you serve on a visit, please send it and we can include it in the court report. In terms of appearing at court for the hearing, you'll get detailed instructions on how to appear. You can appear in person, which we encourage. You can also appear virtually, and the court is in a transitional phase right now post-COVID, where some people attend in person and some people continue to attend virtually. The judge may ask if you want to share anything, but mostly you'll be a silent observer. But it is a good idea to come prepared with perhaps one or two statements you'll be ready to share if the judge does call on you, lifting up perhaps your key request or a notable strength or progress of the youth in the last reporting period. So in conclusion, court report writing really is your strongest tool for advocacy. Again, judges expect them and rely on them and really do lean on them for their decision making. They are required by you twice a year. Sometimes there's an extra hearing where we might ask for an additional, maybe shorter, briefer report, depending on the case, but you'll be notified if that is happening. And as always, we always want to continue to focus on lifting up your youth's voice and strengths so that they can come alive in the courtroom and not just be a number or a report for the judge. Thanks for listening. And please reach out to your case supervisor if you have any questions.